Hey, everybody, this is Brita Long here for the Happier Attorney. And today's Talk Tuesday, we are going to be specifically talking to Texas attorneys about fee shifting. And in the description of the video is a link to this case. This was from 2018. This is Supreme Court of Texas. Venture, Langford, Bass, and Grove, I just say Venture versus UTSW Healthcare. Okay. This was, it's a 53-page opinion. I'm not going to go through almost any of it other than it's talking about attorney's fees. And the prevailing party, this was about a fee shifting issue, and the prevailing party was awarded over $1 million in attorney's fees. And I think that got some attention. This is speculating on my part, but it's a lot of money in attorney's fees. And what was really interesting was the proof of the claim. As we know, prevailing party, it's your duty to show that the fees incurred were reasonable and necessary. And how they did that in this case was the attorney just testified. He did not have timesheets. He didn't have any real details. And quite frankly, his testimony, yikes. It was pretty, it isn't a surprise it got somebody's attention. So he testified he had been doing this for 20 years, that he normally would charge $4.30 an hour, that he knows that that's ridiculously high, which it's not, but okay. And that it pays for a lot of things, running a law firm, and that normally he would have billed 750 to 1,000 hours. That's a big time frame difference. And that, again, it sounds very high, that he had to do a lot of work in this case. He had to search millions of emails and to find documents. He had to review all of those, 60 bankers' boxes worth of documents. Just pretty conclusory, not a lot of detail, lots of depositions. I can see why it got the court's attention. So the Texas Supreme Court, here's the long and the hold of it, the long and the short of it. I don't necessarily agree, quite frankly. But this is what they want. They want a reasonable time frame times a reasonable hour as the basic, as your starting rate. And then the court to increase or decrease based on mitigating or complicating factors. So that's the bottom line. And then the jury can go from there. Now, I've been practicing for a long time. If I looked at another attorney's billing records, absent something glaring, am I going to be able to tell if something was reasonable or not? Probably not. So I'm not sure how a jury is going to, but that's not up to me. So they want your reasonable time. Doesn't have to be kept contemporaneously, but they want billing records. They say it's not a requirement, but highly suggested, and times a reasonable hour. So there's the long and the short of it. Now, can you still use flat fees? Yeah. I would, but this is again for seeking fees from the other side. I've had some anecdotal evidence from attorneys in Texas that courts are still giving flat rates, which is great. And some attorneys are just not doing fee shifting cases anymore. They're just not. It's just not worth their time. If I were to do this, I would still charge a flat rate. I would track my time, keep reasonable descriptions, get all of the other benefits of flat fees, and prove up my fees that way. But charge the client a flat rate. And generally, depending on, you might have to adjust it. And I always would tell clients when I would seek fees, if we get them, it's a bonus. You still have to pay me X, and if we get it, it's a bonus. So that's how I would still go forward, so that you get the benefits of flat fees, that your clients get the benefit of flat fees. And if you try and get them from the other side, here's the courts, here's the records, and your client needs to know you might not get as much as they paid as anytime you do a fee shifting. So the link to the case is in the description. Again, this is for Texas attorneys. So good luck getting your fees out there. Take care.